We're live, and I am back in my basement studio. Let me know if the audio is good, people, and don't mess with me with the Fs. Will this be live on Rumble? Yes, all streams going forward are going to be simultaneously live on Rumble. I think the only problem is that Rumble does not yet have chat enabled, or maybe they do. I have to double check. Rumble did not have chat enabled 2 weeks ago, so they might have chat enabled now, but all streams hitherto going forward are live on Rumble as well. And sooner than later, from what I understand, we're going to have a live feature on Locals, which even when we do live streams, we might do some exclusive stuff to the Locals base, subscribers, supporters, but none of it's going to take away from the free content that's going to be available for everybody. So I don't know if I just yelled too loud. I'm back home, as you can see, and I have my beautiful mic, and I have some actual good lighting, so I'm not going to fade into darkness like I did during the live stream with Nerdrotic. And by the way, how amazing is all of this? By the way, we had last week on our Wednesday sidebars, we had Gad Sad at 1:30 on Wednesday, and we had Nerdrotic Gary Buechler at 7 o'clock the same day, and it's phenomenal. The most amazing thing is, once upon a time, what I wanted to do on YouTube was to do interviews. And it's the most beautiful thing in the world now, where we get to do live streams on Sundays. Robert and I have found, a format that is as informative for me as I hope it is for everyone else. And now we're doing these interviews with other people and just exploring other universes, other realms, and it's beautiful. But it was great. Nerdrotic was phenomenally interesting. Like one of those things where you never really appreciate that there is artistic and historical merit and value in reviewing Marvel movies, because art is a reflection of the time, and the analyses reflect the problems of the time. And it was eye-opening, especially the one thing that we said during that stream. I've always wondered what's with the need to do remakes, to do revamps like Ghostbusters, the remake, 007 remakes of classics. And Nerdrotic made an interesting point. So one of the three of us during the stream said, it's not just a remake, it's a rewrite. And it's something of an attempt to erase the original and replace it with the politically infused remake of the time. And it was an interesting way of looking at it. It's not like destroying statues, and it's not like destroying temples, but it's analogous in that the remake has to override the original and thus become the new original. So it was very interesting. Let me get to some super chats before I actually lose the ability to do this. Anti-gun executive order. We're going to get to this. The woo. I don't even know what is improper terminology. Passports, vaccine passports. I know we're talking about that in Quebec and Canada. Happy Sunday, Viva. Can't wait for the local live feature. Also, indoor dining back where I live. Nerdrotic was excellent. Yeah, you guys are in indoor dining. We're still on curfew. I was at Tim Hortons today. They had one of those printed signs on the wall. It says, because of the curfew that's going to end on February 9th. It was still taped to their ATM, not the ATM, the drive-through. Service au volant, as we say in Quebec. Manifestation of Imagination says, hey, Viva and Barnes, I joined on Locals and sent a message asking if Robert could recommend a lawyer but didn't hear back. What is the best way to send a message? Send it again. The messages go to me, and I'm not always 100% at responding to them. Or david@vivafry.com. Robert's email is online. You can find that as well. But send it again, or I'll see if I can ask Barnes about recommending a lawyer now, but actually send an email. We'll do it that way, or a message in Locals. Viva, huge fan from Ontario of both you and of both of you. Any thoughts on the General Vance information that came out recently? My impression is that Vance was being protected as long as he served his purpose. I'm going to have to look into it. I don't know, but I don't know the story offhand. But thank you for the support, and thank you for the chat. Now, we're falling behind. Did not get a notification this time. I sent this out Twitter, Facebook, community, and I created the link 2 days ago. So it's whatever. It is what it is, and everybody should know we do this every Sunday now anyhow. But The notifications are a problem because if they don't go out, we don't get new people, so it makes growth difficult. Got the vaccine yesterday. Arm was sore for about 24 hours. No third arm out of the belly button yet. It's good. It's we don't even have the option, depending on our age limit, I think, in Quebec, but whatever. It's okay. Oh, no. Okay. No comment. And we got who's on deck this week. I don't know. I don't remember. I asked Robert towards Monday or Tuesday so I can start doing my homework. And I see Robert. Okay, so standard caveats, intros, whatever, disclaimers. No legal advice. If you need legal advice, consult an attorney in your proper jurisdiction for whatever. This is for educational and informational purposes only. Second thing, I'm going to miss super chats. We thank you for all the support. If you're going to get angry if we miss it, don't give the super chat. I do my best to get to them, to bring them up if I can, but I don't get to all of them. And if you're going to be miffed, don't do it. I don't want anyone feeling miffed like what's the word? Grifted them. That's the word. Not grafted, which actually means the exact opposite of grifted. Third thing, YouTube takes 30% of super chat. So if you don't want to feed that beast, totally understand. And if you want to support us, there's locals. I have a PayPal. There's merch, whatever. There's many ways to support us, but no biggie either way. The biggest support you can give is to share the channel, share the links so people know we exist. Can Barnes give a woo-poo suey for a fellow SEC team making it to the Elite 8? Love the show. Go Hogs. I don't know what you just said, but I think it had to do with basketball. Okay, and I see Robert in there. So I was going to do an intro depending on whether or not Robert came early enough. And I was going to pull up an article from The Sun about weddings in the UK are back on. I'm going to bring Robert in because we have to go over the absurdity of the situation at first. And then we're going to get into amazing things on the menu tonight. Chauvin update, because there's a lot of the trial started basically now, like meaningful updates. We're going to go through Sidney Powell's motion to dismiss. We are going to go through the Google motion to dismiss against Rumble. We're going to go through, oh gosh, what else? There's so much on the menu. Oh, Hunter Biden's potentially felonious behavior, which will undoubtedly go under the radar, unless people discuss it and there's a public outrage as to what's going on, which there should be. Okay, let's do it. Let's get this started. Bring him in. Robert, how you doing?
Good.
Okay, I think I like this. We're not going to waste any space. If I can bring up a chat, it might get in the way, but it's worth it. Loved the Nerdrotic interview. Very informative. Haven't watched the Gad Sad interview yet, but he's always great. Keep the interview coming. They were both phenomenally interesting. Both extremely intelligent people with things to add to the contemporary discussion. Oh, okay, Robert, you look well this week. You look well, and you look well rested, actually.
Yeah, relatively. Yeah, I mean, it's my brother was out here, so I usually take this week and the last week off for March Madness. That did not turn out to work out, but the c'est la vie. But but not. I try to minimize distractions and limit. But people start thinking I'm not involved in their case or something. It's like it's only been 3 days, But God bless. But otherwise, it's usually a sort of restive period, but got a little bit of it, not tons of it.
The funny thing is, like when you have a social media presence and you have active clients, I have it to a lesser degree, but you can't hide what you're doing. So your clients know what you're doing because they can see it. So if you don't respond to them within 3 hours and they see you on Twitter or they see you on a YouTube live stream, it can miff certain clients who feel like they're whatever.
Yes,
but
no doubt.
It's the risk of leading a public life. People, you can't lie quite as easily. Not that anyone should. Robert,
well, that's why I used to love vacationing in Cuba. Hypothetically speaking, I vacationed in Cuba. Because there's no back in the day there was no phone access or nobody could reach you. You were literally off the grid. So they might be mounting up the complaints, but you wouldn't see them until you got back.
See, being disconnected right now is an extremely anxiety-inducing prospect for me. And I know, Ruben says disconnect and don't look at your phone, but I can't do it. And it's the fear of what's going on, and not necessarily in the social media world, just personally, professionally. Did I miss something? It's worth the constant anxiety to avoid these spikes in anxiety. Okay, we got Beavis Wallace says from McAllen, Texas. Looking back at the election and recent events, I realized my only news source is Viva and Barnes. I've been better informed than anyone. When are you starting your own channels? Hey, Robert, when is Trump starting his own network?
Yeah, well, I mean, we kind of do have a certain degree of exclusive content on our own channel on Locals. Viva barneslaw.locals.com, where you can get a lot of insight that we can't even some of these topics we can't even discuss here. But it's intended to sort of curate a community that provides old school message board support, and a shout out to all the Locals board members, because increasingly I'm getting a lot of my links and information from other board members. Not only a lot of them post great memes, a lot of them, there's about 200 posts a day, about 1,000 comments a day. I read most of both, and tons of insightful information to where I don't even need to go to other platforms to get to make sure I'm staying on top of certain legal and political and cultural news. So, it's been great. And that's been fun. Oh, and for this Wednesday, it's the future ruler of Earth, who is our guest, Mr. Doomcock.
Oh my goodness. Okay, well, I have some homework to do for Doomcock, and so everyone appreciates also. Robert puts up, it's like masterclass material on Locals, and it's like there's some content with all of our content is free and will always be on YouTube, Rumble, etc. But there is some stuff that Robert and I create for supporters. Robert puts out these hush hush episodes. The one I just watched, I don't get to watch all of them, but I just watched the original Deep State, Stanton from the Civil War era, and what I learned, it's amazing. I just hope I can retain 20% of what I learned, because it's like what Homer Simpson said. You learn one thing and it pushes something else out of your head. And
Locals is adding playlists. It's available for desktops, but will be available mobile pretty soon. They're going to be announcing on Monday a bunch of other new stuff that they have. And so that people can just go through them anytime they want. Designed to be not too long, but sufficient to cover things. But if people want to stream them at some, just back to binge them, they can do that down the road. So it's created for that purpose. And part of the purpose was to curate, to blaze the path so that other people could follow. Allison Morrow is going to be going that path, because it's recognizing the censorship suppression problems of YouTube, and that it makes more sense to start providing unique content to help sort of both brand and to get independent information out there in a continuous, consistent manner. And she's in the spirit of a case we'll be talking about later tonight, which is she's a Cheryl Atkinson style journalist. And what happened to Cheryl Atkinson is right out of a Hush Hush episode.
Yeah, we're going to get there, because the Atkinson one is the one that I didn't have enough time to get into. So you're going to have to walk me through that. Before we even get into this, because everyone asks, you have 2 new books behind you. What are your book recommendations for the week?
So this is Confessions of a Tax Collector. Tells you how insane the IRS are. It's someone who, accidentally became an IRS agent, and it basically reads like Lord Conrad going into the heart of the jungle, which was a great book, by the way, that helped destabilize the credibility of colonial empires, particularly the Belgian Empire, that he wrote because he was really meaning to deconstruct and destroy it by his great novel. Of course, that became the novel. That was the basis of Apocalypse Now, the film, as well. It became parallel themes. But this is a great insight into how insane the IRS really is. And then the other part is about the buildup. What's the full title? That's right. 2 Men Before the Storm. It's about the buildup to the Dred Scott case, which will be one of the famous cases I'll be discussing on our Locals channel. There's a Charlie Manson case, a Silk Road case, which we'll tangentially get into tonight. It's a new movie out. And those will be some of the famous cases that I'll be debriefing for our Locals supporters at vivabarneslaw.locals.com.
Oh, and one more thing, actually, before we get started. Okay, I got a message from someone on Local, so now I'll just make sure that I screenshot it. Someone sent me some paintings by mail, and I wanted to show one of them, because I know he's watching now. And this is the one, not to say that I had a favorite versus the rest. This was my favorite. And so
fantastic.
I keep everything. I just can't put it all on the wall, but this one's going to have a place somewhere very soon. Okay, Robert.
Well, you could end up with like a Jordan Peterson or William F. Buckley kind of wall. Have you ever seen it? Peterson, his whole place is just art. On every level, every piece of wall that exists, there's a piece of art. And when I was at Buckley's place many years ago, that's how Buckley. I was impressed. It was like old European style art everywhere. It's just fantastic art everywhere in the walls.
Well, I think if I build out a studio, or at least I decorate this to be a studio, it might be a good theme. Is a subscriber.
big improvement on whatever's on Tim Pool's wall. I get distracted by that stuff. It's all this like murderous, like what in the world is that? And I get it's supposed to be like hip or something, but it's too dark.
Well, I love Nerdrotic's backdrop. I mean, I got distracted the first few times watching it, but there's a tremendous amount of detail in there. Oh, and you know what? Here, M. Robertson 007 says, "Hey guys, Robert, there's a 21 behind you. What brand is it? Is it Ochtentoshan or is that?"
People are going to think that was intentional, but it's totally coincidental that there's 3 21s behind me. That there's no other meaning behind it, not the least that I'm aware of. So it's the age of the different scotches. So there's a Bushmills 21. What's that one? Oh yeah, that's the Redbreast 21, which is nice. And then the one in the middle, oh yeah, that's the Balvenie. Actually, that's what this is. It's 21-year-old Scotch that's aged in Port Oak barrels. So it takes a little smooth edge to what can otherwise be a little strong with Scotch for my taste. So it's a particularly, I like it. Glenlivet does one of these. Glenmorangie does another one, but this one is particularly good.
All right, now I missed the chat, which we're going to get to. I'm going to take 2 pictures because it is in rubles, and the name, it looks like Ebren Anacope. Oh, that's hopefully as good as I can do, and it's about Google. But we're going to get into that actually at some point. So I'm going to screenshot when we discuss Google. We're going to get to that. And now the chats have been coming in too much that I cannot bring them in anymore. Okay, let's get started with the first subject of the evening. I guess what we want to do. Okay, we'll do. They're going to contact Tara. Thank you very much. First subject of the evening, Chauvin update. The trial has begun. Jury selection is completed. And I mean, what's the status? We have a full panel of jury. We have a full panel of jury. 14, 2 alternates. Have they been impaneled yet?
They end up impaneling a 15th one. So they come in to formally take the oath tomorrow morning, and opening statements are tomorrow. And opening statements will probably take up the whole day. And so because of the nature of this case, it is expected to go 4 weeks, about 6 hours a day of trial testimony. That's pretty normal for state court. Some state courts are even shorter. Federal court, you often go 8-10 hours. Though this judge is a little bit on the longer side. What I think, given all the motions in limine have been determined, now from a jury pool perspective, it is the prosecution thinks they got the jury they wanted based on demographics, is my read. That the jury pool, a typical jury pool would be mostly white, would be about half white men. It would only have 1 to 2 minority members out of the 15 on it, based on Minneapolis's and Hennepin County's jury pool. Instead, what they have is 6 minority members of the jury, very few elderly. So it's a young millennial leading. So demographically, by polling data, it's a conviction-oriented jury. And many of their statements pre-trial were statements that I think most people would interpret as leaning towards guilty. Robert Grueller at the Watching the Watchers, also he has a locals page, watchingthewatchers.locals.com, and he's one of the people we interviewed for the Sidebar show on Wednesday. Great life story, empowering life story of what he's overcome to achieve where he's at, and why he cares about the things he does. But he did a breakdown. He thought it was about at least 8 to 9 jurors lean guilty. And I think that his analysis was pretty, I would have put him more at leaning guilty is the only difference. Now, my view is the leaders of the jury, if whoever the foreman is, will tell us a lot. If it's that social media seeking juror, the second juror seated, then I think Chauvin is in trouble. If it is an African-American male juror that ends up being jury foreman, particularly one that I have in mind, it may be at least a partial acquittal jury. So the defense clearly believes, based on individualized information that they know about each of these jurors, that they think a lot of the particularly African-American male jurors may be a acquittal-oriented jurors on 2 of the 3 charges, on the most serious charges, including counts that are more serious than the ones than Chauvin was willing to plead to. And so that's the jury update. So the opening statement, all the evidence has now been ruled on for the most part in the motions in limine stage. Go ahead.
Oh yeah, I was going to say just to remind everybody or to inform those who weren't watching last week, the biggest evidentiary ruling was allowing history of George Floyd's, not prior criminal history, but rather prior incidents wherein apparently he attempted to consume drugs in order to avoid or evade arrest type thing. One in the last time it landed him in the hospital, it was 2019. So that's going to be admitted, and Chauvin's prior history will not be admitted as evidence. That's accurate?
Exactly. So the prosecution's, I think, opening statement will focus heavily. We'll see what they're. If I was them, I would include everything, but they may try to only include part of the video. We'll see. But their storyline is going to be accenting the time in which Chauvin is on the back of George Floyd, and on to some degree on his neck. And that there's some dispute about whether it's on really the upper back or the neck in terms of where his hold is. But their focus is going to be on the time period that's taking place. And that while that's taking place, they're going to emphasize that other officers were saying we probably should flip him over. That prior training in Minneapolis said that when they're no longer resisting, flip them over. That a paramedic not a paramedic, but someone who works in the fire department who was there at the scene was telling him to flip him over. That someone that knows MMA was saying, based on where his hold was at the scene telling him to flip him over. So they're probably going to accent warning after warning after warning after warning, and Chauvin ignores them all and Floyd dies. So that will probably be the core of their story. They won't get in Chauvin's history, and we'll see if they try to deal with in anticipation the defense. A smart prosecutor will do so, but some of them are so arrogant and live in their own world that they refuse to do so. And so we'll see if they're smart and try to anticipate certain defenses that are going to raise and try to preempt those defenses. The defense opening statement is likely going to be focused on that evidence that was introduced, that was declared to be introduced last week. And their story is going to be what happens is Floyd gets pulled over. He has a bunch of contraband on him. He has fake currency on him. He just committed a crime at the local store. He has illicit drugs on him. And when this happened before in 2019, almost a year to the date in Minneapolis, what did he do? He tried to hide the evidence and buy time. And he did so by not complying with police all the way through so he could try to get rid of the evidence. He tries to get rid of the dollar bills. They're later found crumpled in the car. He later tries to get rid of the drugs. They'll show a picture of him with what appears to be something in his mouth that could be fentanyl. They'll show later that in the car they found parts of fentanyl spit out or lost with his saliva on it. And they'll show the toxicology report that showed he had an extraordinarily high lethal dose of fentanyl in his system at the time of death. And they'll talk about how their medical experts will have concluded that the knee on the neck had nothing to do with the cause of death. Their secondary aspect of their defense will be that this is consistent to his training, and they'll show photos from training manuals, including training they borrowed from Israel and other places, such that these are internationally recognized standards where this is the norm. I don't know if they'll get into data, because this part was not clearly ruled on prior to trial that I saw. But if they did, they would get into hundreds of people this detention had been used on, and of them, none of them. It was not uncommon for them to pass out, but so it wouldn't be unusual to see a person passed out underneath you. But it was none of them had ever died before. So Chauvin's experience was this was proper training, this was proper protocol, seen it utilized multiple times, done it himself. A smart defense lawyer will try to introduce his client's testimony through opening statement in anticipation of what his client will testify to, even if he decides ultimately never to have his client testify, because it's a way to get that story in advance. Johnny Cochran gave one of the best opening statements and one of the best closing arguments ever in the O.J. Simpson case, which will be a future broadcast on the innocence of O.J. Simpson for the murders.
We might have to get Dershowitz back on for that particular episode. See, one silly question, I think. The whole counterfeit bill. Like, I don't know how that works. Is it alleged that he had it by accident, or that he was part of a counterfeit ring and he was trying to launder the counterfeit money into currency? Like, is that known how he came in possession of the counterfeit bill?
Not that I know of. Not that I've heard as yet. So just that he had it, that he passed one at the store, and that he had two more on him and tried to crumple them up, and it's why he's not putting both hands on the wheel. That he's and they'll focus. The third thing they will focus on heavily is the whole interaction, the context of the 2019 interaction with the 2020 interaction, so that when Chauvin shows up, what the other police officers have been dealing with is someone who's refused to do anything, has refused to comply, won't put two hands on the wheel, won't get out of the car in a timely manner, won't get into the car, won't stay standing up, keeps falling down. Once he's in the car, is being disruptive and trying to not be in there, says he's suddenly claustrophobic and can't do it. And then he's saying he can't breathe before he's even ever on the ground. So that context will be a radically different context than what most of the jurors will have ever heard before.
I have no doubt that the jurors are going to learn information that they have no idea even exists. Like, they would not be able to contemplate some of the information they're going to hear. I'm sure of it. Are they going to plead the issue that Nate Brody covered it on his channel, Nate the lawyer? There was another case out of Minneapolis, virtually identical from what I understand to this case, where someone passed away after a knee using the Minneapolis standard protocol as per their website and training, and was acquitted. So, I mean, at what point do they plead precedent, and what power does precedent have in a case like this?
Usually none. It may come in through, if they're smart on the defense lawyer side, through cross-examination of the government's experts. The government will have law enforcement experts that will say our training said not to do this. They'll have medical experts that say the cause of death was what Chauvin did. Defense will have experts that say, no, this conduct was consistent with his training. And they'll have medical experts to say, no, it wasn't the cause of death anyway. If you're smart on the defense side, you will try to get into evidence through one of the government's experts. If they say, hey, training was A, B, C, and D, to say, isn't it the case that courts have recognized as part, and that what you would do is a cross-examination like this. You recognize as part of training as customs and practices as recognized by court decisions. Try to get them to say yes. Isn't it the case that a Minnesota case, an 8th Circuit Court of Appeals case, said that a 15-minute neck hold was not unreasonable force as a matter of law in the months leading up to this case even happening? And that would be the way you would try to sneak it in. Judges usually try very much to keep it out, thinking it's more prejudicial than it is probative. And so that's an open question. We don't know what the expert witness looks like, testimony looks like. We don't know what some other aspects. Some of that will likely be previewed. There'll probably be a very technologically sophisticated presentation because this is highly unusual prosecution. It's mostly being prosecuted by private lawyers, by some of the top trial lawyers across the country and appellate lawyers across the country, all coming in to weigh in against one guy and one defense lawyer. So the resources is definitely a mismatch, but certain facts don't change. And some of those facts point more towards acquittal, at least of the top 2 counts. And I think, of course, there's legal problems with those counts too. But my guess right now, if I was a betting, there probably will be betting markets on this. My first bet on a legal case was that O.J. Simpson would be acquitted. Made nice little cash on that when I was a young fellow.
Oh my God.
I'm not saying whether I had a client maybe bet on felony acquittals in his case, but if he did, hypothetically speaking, he made a nice little cash cow on that. But that's another story for another day. But if there is, my odds, I would say 50% chance of conviction on either of the top 2 counts, 75% chance conviction on the second-degree manslaughter count. Just because of the jury pool. If it turns out this really was an impartial jury that was really open to the evidence and not worried about the consequences of their verdict, then I would say 25% chance conviction on the top 2 counts and only 50% because the causation issue applies to all 3 counts.
Someone asked who's paying for Chauvin?
The police union.
Okay, and who's paying for the prosecution, bringing in private counsel to prosecute? I mean, it's a stupid question, but obviously taxpayers.
Yes, indeed.
All right, and then I was reading up on this also that one of the other big decisions, although it's an older one, was not to change venue. And from what I was reading, the refusal to change venue in the event of a condemnation could itself be substantial grounds for an appeal. So, I mean, do we see that happening in the event of a conviction, that they're going to invoke the grounds that there was not a change of venue, that the jury felt pressured by virtue of the climate to condemn or to convict?
Yes, it's just not a very strong ground after the Enron decision of the U.S. Supreme Court. Once they could try the Enron defendants in Houston, your ability to get a reversal for failure to change venue is very, very low. What you need is the kind of polling data, that someone like Richard Barris, the People's Pundit, I utilize him for those kind of cases to show. You need data, you need evidence, you need to create a real record. They didn't create anything close to that record here. So there's a lot of people inferentially can see the problem, and the judge was somewhat concerned with the problem, but they didn't create the kind of record that would make that a reversible issue. I think the top 2 counts, even though one of them was reinstated by the Court of Appeals, if the Minnesota Supreme Court enforces the law, the top 2 counts, if he's convicted on either of them, I think should be thrown out on appeal. And that may contaminate their conviction on the 3rd count. So they may never get anything affirmed. Chauvin himself, no matter what happens here, is kind of screwed because he's caught on a bunch of tax charges in the federal system. So, and in the state system too. So he's going to jail. He's lost his job. He's going to jail, prison, no matter what, going to be bankrupted no matter what. He's trying to avoid 40 years in prison. So his big thing is the top count. He was willing to plead to 3rd degree. And that's 20 years. Typically you get 10, usually you serve 5, something like that. He would probably get a harsher sentence just because of the nature of the case. But even that's manageable. Their real thing is to acquit him on the big count, the felony murder count.
Someone asked, why can't he claim qualified immunity? Does it apply to criminal accusations?
Exactly, and it shouldn't apply to anything. But that we'll discuss that later in the Cheryl Atkinson case.
Yep. Okay, so that's it. So now the opening statements start tomorrow, and then it's going to be 5 days a week, 8 hours a day.
Pretty much. The actual trial testimony will probably consume 6 hours, but because of the breaks.
Okay, and it's going to be live streamed, so everybody who has, if you're locked down, you have all the time in the world to watch it. It's going to be fascinating. I'm going to be tuning in and out, but kids are off school for next week, so I'm not going to be, unfortunately, glued to my TV. Although I will be doing a panel tomorrow at 10 o'clock, panel with the AEI. I shared it on Twitter on free speech, so everyone should tune into that if you haven't.
They're doing great work on the lockdowns too.
And the panel's very interesting. I was actually surprised at how open-minded. I mean, obviously, a free speech panel are going to be open-minded, but it was nice to have a discussion with people who appreciate the value of free speech, even if they don't always like it. So that's tomorrow. Okay, so Chauvin, we'll do the update again next week.
Yep.
Let's go into the one that I have a particular interest this week. Sidney Powell's motion to dismiss, if we can. So,
sure.
For those of you who don't know, Sidney Powell has been sued. Sidney Powell, Lynn Wood, Giuliani, Pillow Guy, Michael Lindell, I don't mean to demean him, that was my Pillow Guy, have all been sued for $1.3 billion for defamation by Dominion. Sidney Powell filed a motion to dismiss, it was this week or last week, but recently, seeking to dismiss the defamation claim. And it's a 90-page motion to dismiss. There's jurisdiction. It raises everything. But the one thing that it raised that made the headlines, everyone in the mainstream media is running with the headline, Sidney Powell's defense in the motion to dismiss is that no reasonable person would have taken her statements to be statements of fact. And then they pull out the section where she says it was obviously opinion, without really fleshing out that the argument is opinion, as in legal opinion, to be proven in a court of law because it was in the context of pending litigation or upcoming litigation, impending litigation. I have 2 questions, and I think I'm confused, and you can hopefully clarify this. It came up in the Osundaira brothers suing Mark Garagos and Tina Glangian and Garagos law firm for defamation for things they said about the Osundaira brothers in the context of the Jussie Smollett representation. And in their lawsuit, they got ahead of the ball in terms of what I thought was litigation privilege, in that you can't really sue attorneys for making statements about their client in the context of defending their clients, setting aside exceptional circumstances, because it would chill the effect to practice law if lawyers would get sued personally for defamation for making factually incorrect statements that are part of pleadings that need to be proven or disproven. So litigation privilege as a whole, can you just explain how that works and whether or not it is or is not at play in Sidney Powell's motion to dismiss?
Well, our case law around it is not the most robust. There's some lack of clarity and key components. Here's what's definitely clear. If anything you file in court and that is later reported is absolute litigation privilege. So nobody can be sued, including the media, as long as they report accurately and fairly what was said in court, for anything you say in court. So years ago, for example, I had a case that involved a very powerful individual. And my client was his tax CPA, was his tax return prepare guy. And he got into trouble because of part of a tax shelter that wasn't done by my client, it was done by somebody else. But this guy, who was very, very politically connected, he was the biggest donor in the history of the Democratic Party at that time. The very, just big in Hollywood, big in the music industry, big in a wide range of spaces, big in publishing, would later own Univision, so people can look him up as to who he was. So he was waging political and legal war, in my view, against my client, trying to help railroad my client to save his own rear end, and for things that my client wasn't responsible for. And I had to detail why my client was unfortunately picked up with 2 false passports and $300,000 in cash. So I was trying to get him out on bail. I did get him out on bail, by the way, and got the U.S. attorney that was bringing the case ended up leaving when he was about to get promoted to one of the top positions. Too bad, so sad. But one of the arguments I was making was that my client had good reason to fear for his well-being and safety, based on what this very powerful billionaire had said to him over the years. And I said this inside court, that what this guy had bragged about getting, I won't go into detail here, but let's just say it was some unfortunate, it'd be the kind of things that might motivate you to have a few extra passports if you thought he was coming after you, because of what intelligence agencies he was connected to, this billionaire. Well, unfortunately for this billionaire, the media reported it even differently than I described it. And it spread around the world that this guy actually had a history of actually getting people whacked by these different intelligence agencies, which is not what I said. I said that he had a history of saying and claiming he did. So too bad for that guy. His reputation went phew, but couldn't have happened to a better individual. But if they had reported accurately what I said, they were completely immune from suit. Because it's what's said in court. So you file a suit, and let's say you're the lawyer, you can talk about what you filed. You can talk about how that is. All of that is also protected because you're referencing what was been filed or said inside the courtroom. To give another example, the prosecutors who have lied about Kyle Rittenhouse repeatedly, they do their lying through their court filing, knowing that nobody can be sued for the lies they file in court. So now the flip side is lawyers tend to assume that anything they say in anticipation of litigation, or that was said as to defend or justify their litigation, but was not said in court, is also definitely immune. And there you're in much more riskier position. Sometimes it's immune, sometimes it isn't. Frankly, it depends on which state you're in, which courtroom you're in. And so that's the scope of it. And that's where that's where a part of, I believe, the Smollett case moved forward. Though this is not, Smollett's not a named party, but it's about what his lawyers did to the 2 brothers. And the same would be the case with Sidney Powell. Some of what she did and said fit within litigation privilege. Some of what she said and did depends on the court that she's in as to whether litigation privilege applies. So I would say the one analysis not to read and watch is the imbecilic advice by that litigation loser, Legal Eagle. Who did it's the YouTube is bombarding his version of Sidney Powell, and he's frankly here's some advice to folks out there. If you're going to talk about a defamation defendant and the lawyer in the defamation defense, don't defame them in your analysis by falsely reporting. This is like fair reporting, immune. This is another version of litigation privilege. They can talk about what her defense is and be totally immune. They can't mischaracterize what her defense is, like little David Frenchie did, and be immune. Both of them could be sued by Sidney Powell for libel because they misrepresented what her defense was in court.
It is. I mean, it's shocking just because, the headlines say it. No reasonable person would take it to be a question of fact. It was relatively, I still think she's in trouble.
No reasonable person would think I was telling the truth. No reasonable person would believe me. It's no reasonable person would interpret this statement to be a factual statement rather than a statement of opinion. And what Legal Eagle did was deliberate defamation. He defamed Sidney Powell. He lied about it. She should just sue him for heck. There'd be some lawyers willing to help for that for free. But and David French, same thing. Neither one. You pointed it out to David French. You're like, did you actually read the motion or did you just read the newsline versions of it? All these media people lied about her defense, and it's extraordinary. It's like I've been extraordinarily critical when we have suggested serious problems with a lot of what she said from the very beginning. But so that's where you can cover her weaknesses in this legal case fairly without lying. But they can't. They had to lie about it.
No, and the thing is, I remember my thought progression with Sidney Powell is she gave the first interviews, and I said, she looks like she knows what she's saying. She's speaking with determination and confidence. And then 4 days later, I was saying, like, it's nice to speak with determination and confidence, but if you don't actually start producing the evidence that you said exists, it's not going to look well, neither in the court of public opinion or the actual court. And it just slowly went downhill from there. And then you and I began exploring these other things, which I had no total appreciation about, which we don't need to get into now. But yeah, it's so. But even in her motion to dismiss, it was not what the media was saying is nobody would think it was a fact, and therefore they would think I was deliberate, like lying or didn't believe it. All that she said is, I'm a lawyer representing a position, and when I make the statements, everyone should assume that they are statements from a lawyer that need to be proven in court. Now, I still disagree, because saying that you have the evidence is different than presenting a position. And I genuinely believe she said, I have the evidence, and obviously never produced it or did not produce adequate evidence, which is a judge going to say that's a lawyer doing his or her job as an attorney, trying to get the public set up and involved in a lawsuit? Or is it a lawyer saying that they have evidence that they don't have, or, as alleged in some of the other proceedings, a lawyer preparing evidence or falsifying evidence in order to create a lawsuit? But I can't understand the litigation privilege aspect of it, where she's not specifically invoking it, but she's effectively saying, I'm a lawyer representing a position, and everyone should have understood that what I was saying was what I intend on pleading in court, and it'll be up to the court to determine whether or not it's true.
Now, in truth, she also could have couched it that way, which would have protected her position.
Yeah.
And some of us were saying that loud and clear at the time, publicly and privately. Unfortunately, certain people didn't want to listen. And so they're in a problem of their own creation. So I'm not overly sympathetic. And I think that to some degree, it was not the best defense to raise for the court of public opinion. Because like when I was doing all the Alex Jones work, very careful about the defenses that I raised, because I knew how they would be misportrayed. So like, he brought an anti-slap motion. The goal was to make it clear we weren't seeking any fees or costs from the other side, even though he's entitled to it. Because otherwise the media was going to run with a headline that was Alex Jones demands these poor families pay him a bunch of money. Right? I mean, so you have to know how the court of public opinion is going to interpret things when you're a public actor trying to protect your public reputation. And that could have been couched a lot better. And frankly, some of the claims were not legally that strong. Some of these claims, a lot of them were just statements of fact. They just weren't opinions, in my view. I don't think a court is likely to interpret them as opinions.
No, and especially like when we had talked about it from the beginning, certain even if they were opinions, even illegal opinions to be proven in court, history of the companies, the corporate structure of the companies are not, these are, if they are opinions to be proven or disproven in court, they're arguably reckless to not just get certain basic facts right. But I'm a reasonable person. I took it to be statements of fact. We have the evidence, and we're going to release it. And then, as time went on,
specific, what people forget is just because an opinion doesn't mean it's immune. It has to be so vague and so uncertain that nobody can determine what you're saying from a factual perspective, that no jury could make a factual finding concerning it. Saying someone committed perjury is an opinion, but you can be sued for it. The U.S. Supreme Court determined that 20 years ago. So people tend to forget. They think anything that's an opinion is protected. Ask the New York Times, it just got smacked around in New York that we talked about last week. Not every opinion is protected. If there's anything about it that infers a fact, even if it doesn't state a fact, can constitute actionable defamation under the law.
That's it. It's like saying, in my opinion, this person committed a crime. Well, I mean, you're making an opinion of a statement of fact, and you can't hide the statement of fact behind the in my opinion, allegedly, purportedly, et cetera, et cetera. And it goes back to a discussion we had a while back, and it comes up time and time again, how you take these battles to social media. It's always risky to talk about a case, but how it could have been presented, where I think there would have been no exposure. We're going to take this to court. This is our client's position. This is what we intend to prove in court, and it will, and that's where it will be adjudicated. Yes. But everyone knows when you couch it that way that it's not soft talk. It's just that it's an attorney speaking properly. What she did was much different, and we were talking about it from the beginning. I was a little slower to it than you, but So that's interesting. It's litigation privilege, absolute in written pleadings. And as we've seen, and as I sort of did my own research, but it's jurisdictional and court-wise, if you stretch the bounds of what is necessary to represent a client, it can land you in court, as it did in the Osundara brothers. They filed a motion to dismiss against Garagos and Glangian, dismissed all but one count, and they're going to have to defend against defamation when they referred to the whiteface aspect of Jussie Smollett's attack and implied it was a hate crime, which the Osundara brothers alleges defamatory.
Yes. And that's where, they could have said, this is what we said in court. They could say, We believe the evidence when presented. We believe this evidence will be. But they didn't do that. They didn't couch it. They didn't caveat it, because what the courts recognize that if you couch something, then they realize, okay, you're asking the person to look at the underlying source. You're asking the person to wait for a future event. You're not saying that this is definitely the truth. You're saying you believe this will in fact be proven once evidence is, et cetera. And there are a lot of ways to couch it. Powell, for example, could have been said, the information I've been given says that this is what's happened. The other side disputes it. I'm going to take it to court to see if we can prove it. That would be much harder claim to bring. Yeah. And I can absolutely, I've seen this, and there's mail ballots that came from China. The Epoch Times confirmed this past week another thing that we were talking about 3 months ago, going back to that earlier super chat about we've been more accurate than 90% of everyone else. And that's just the God's honest truth. Is that said from the get-go that whole ballots coming from China were somehow secretly laundered in, and they were counted, made no sense. The whole Italian story made no sense. The German server story,
the German server. I mean, and I'm skeptical of everything in general, but we discussed it. It's like none of this makes any sense. You specified at the time, raised all of the awareness that this could be a harmful distraction to the legitimate questions of law. And it panned out to be not just true, but prophetic, where, it's a shame more people weren't listening. More people in certain positions were not listening. Robert, in my analysis of the Osundara brothers and that judgment that dismissed all but one claim of the defamation against Garagos and Glangian, am I wrong in thinking that the judge, that's a needle to Garagos and Glangian? Because that judge could have easily found a way to this. I thought the whiteface statement was among the least, if there were any that were defamatory, of those statements. So, for my own benefit, for my own ego, what on earth was up with the judge leaving that one claim for them to proceed on?
So it doesn't go to appeal right away, is my take. It's similar to what the federal judge ultimately did in the Sandman cases, that when he got pushback from a lot of litigation we were filing in front of the same judge, he decided, okay, the best way I can avoid a Sandman appeal and a reversal is to let something move forward. I'm going to let one claim out of the 20 move forward, knowing that meant they had to go through discovery, and usually those cases then settle, and that's it. Particularly Lynn Wood's cases tended to settle. So that's how that doesn't surprise me. That's what a judge will do when they think, there's enough wrong here about what happened that I might get reversed on appeal. Yeah. I'll leave something in so that it goes through discovery. It will probably settle, probably will never see the light of day again. I don't have to worry about appellate risk. And there's some fairness and justice done for something that feels under fundamentally something that was wrong here.
All right. And incidentally, one of my other lawyer sources who checks the court files mentioned that the defamation case has been put on hold pending a resolution of the criminal case. So we should probably not have an update on the Osundara brothers defamation for a little while. Now, Marcus Horn asked, and I can't read the question out loud because YouTube has very strict rules, as Rudy Giuliani knows, about his endorsements. Why Robert has something in his hand that he doesn't use. If he were to use it on YouTube, it would be a problem for YouTube. So that is the answer. That is the answer to the question. Marcus Horn, and thank you for the chat. Sorry, I missed it.
It's the Wise Man is the name of this, let's call it a health stick. Evidenced by George Burns, lived a long, long time. That's all I'm saying. Mark Twain, he used the health stick 10 times a day.
Yeah, and George Burns' joke is, "What do your doctors say about you smoking and drinking?" And he says, "I don't know. They're all dead." That was
yes, indeed. Yes, that was great.
Okay, so what do we move on to now? There was one. Do we do a real quick pivot to the Google case, because it's going to involve a question again to which I don't know the answer? Sure. Google people, everyone, Rumble Media, not Rumble Media, what am I saying? Rumble Videos, Rumble the platform where we put all of our content.
Yeah, well, there's a bunch of people watching tonight because we're live streaming on Rumble as well.
If anybody's watching there, let me know how many people are watching, because I don't have two screens up. I'm still only on one screen. So Rumble is suing Google for Sherman Act antitrust violations. I did a Viva on the Ice where I just walked through the lawsuit. It's a lengthy lawsuit. It's an interesting lawsuit. They're basically saying Google is using its monopoly to favor certain search results in Google search as relates to YouTube videos, to the detriment of other platforms, Rumble in particular. They have their own test as to how they believe they can prove that once the video is shared by partner, I forget the wording, but basically Google will show search results that do not even go to the original video source when it's on Rumble, and instead favor other search results and even unrelated search results on YouTube. And they invoked Sherman Act antitrust violations, one of which was time. That apparently Google ties in the YouTube app to installation on smartphones, thus stifling competition. Google just presented a motion to dismiss, a partial motion to dismiss. And we're going to get into that question in a second. But bottom line, they are seeking to dismiss on a Rule 12b-6 the tying count, the count 2 for tying, but not the count 1 for favoring YouTube search results. So I mean, that's the bottom line. They fleshed out basically that, you know, why they should dismiss the second count is that Rumble hasn't even alleged the 3 essential elements to a tying claim. So Robert, I mean, what do you think of the essence of their motion to dismiss? Prediction on where it's going to go, because it seems like it's a legit complaint on relates to count 2. And then the question is, why not go for a full motion to dismiss and set one aspect of the claim to proceed to discovery?
You know, the only reason why they're even able to bring a motion to dismiss, in my view, is because of the Twombly line of cases where the U.S. Supreme Court elevated what a 12b-6 did. Traditionally, under a motion 12b-6 motion to dismiss, you have to presume all of the facts that the plaintiffs alleges are true. And you have to presume all of the inferences that anyone can infer from those facts are also true. And you say, well, you know what? Even if every fact is true and every inference is true, there's still not a claim under the law for some reason. And instead, what Twombly did is the U.S. Supreme Court, because they wanted to protect politicians in this particular case, they said, no, you really need to plausibly plead. All that was going to do was invite courts to superimpose their own judgment and dismiss cases that don't meet the 12b-6 standard, and that's precisely how it's been misused and abused. That's why throughout their motion to dismiss, you see not they failed to plead, but they failed to plausibly plead. That just creates a nightmare set of problems. Down the road, the Supreme Court's going to have to reverse that, reinstate the original rule. But until that happens, you're at the whim of the political biases of the court. So that's where they could lose because of that. They're stuck in the Northern District of California because of Google's related issues. And a lot of those judges there, very big tech friendly. It may be why Steven Crowder hasn't sued yet. They talked about the beginning of February filing suit. We're going in April. No suits filed as far as I know. And I think in part it's because if they research it, they'll realize that's a tough venue to bring a claim in. But particularly if you're suing big tech. There's a reason why big tech engineers all cases to go there, and there'd be too long an episode to get into how that happens, but they're very effective at it. But but as to the time, some of what they're saying is based on their own version of the facts, and that's my problem with their motion to dismiss. It's their version of the facts is, hey, we don't really tie. Now they claim it isn't plausibly pled, but it was clearly pled, so it's just their interpretation of the pleadings as to whether they suffice. But that's not a pleading issue, that's their interpretation.
And moreover than that, like they're trying to incorporate by reference the Apache and the GNR licenses, which I'll admit I don't understand. But my impression is they want to bring in these licenses, even though they weren't alleged in the proceedings, by saying, you know, that they're necessarily incorporated by reference, knowing that these particular licenses may not show what Rumble needs to show, but might be totally irrelevant. So
and really, that's a motion for summary judgment. When you add things to a document and a motion, if you add things to your complaint, then they are incorporated into the record as part of the complaint. But when you don't, when you simply incorporate things as part of the defense, then that's a motion for summary judgment, in my view. That's no longer a motion to dismiss. So I think the other thing is they're playing around. They know almost no judge understands the technology. So as far behind as we are and not knowing a lot of the tech, nowhere near. Remember that the parlor judge? I mean, that was it. I mean, Nick Rekieta, who also is on Locals, Rekieta Law, did a great mockery of just what an embarrassment. Like he basically said, people that are senior status probably should never take a big tech case. Probably should be a rule against it.
Well, you know, it's not to be ageist. My dad would be an amazing judge on a tech case because he understands it. But I go back to my only experience of a tech case on a supernumerary, semi-retired family law judge who, after 20 minutes of someone explaining what SEO was and how it worked on Google Rank, said she understood it. And I'm like, no, you don't, because I don't even understand it. I've been in the file for months now. So
they're like what the commenter was talking about, the chatter, is definitely the case. And as one of the people responded in your YouTube on the YouTube comment section, they're playing games with what they're doing. And this is what Amazon did. Remember, Amazon pretended, yeah, we host Twitter, but not really host Twitter. And it's totally different and dissimilar. Not really, if you understand what's taking place. And the same with them. They're trying to. The tying accusation is part of all the DOJ and state attorney generals and private class actions they're facing all across the country. So pretending they don't tie is very deceptive.
Well, one thing I was going to say, and I should have mentioned it in the video, is it was fleshed out in the Texas antitrust lawsuit. And to say they don't tie, okay, well, how do you explain the fact that the app is pre-installed and cannot be uninstalled? Like, that's another thing which I suspect. I told I flipped it obviously to Chris Pavlovsky at Rumble. I said, like, go read through the comments, because the crowdsourcing of knowledge on the internet is amazing. But I knew that you can't uninstall these apps, but I don't understand. I know I don't understand it. I'm never going to understand it. I have a blackout when people try to explain it. But let me get to Evgeny's comment, which I had from before, concerning Google. Android OS is BS. The tying thing is Google services. Google was sued in 2016 by EU for antitrust violations because of it, lost in 2018, and was fined $5 billion. So screenshotted that. I'm going to post that on social media. So it
shows. I mean, they think they can gaslight the judge. The confidence that showed is quite, which is frightening more than anything else. Because if you spend any time digging into this, you'll guess very quickly that Google is not being forthcoming. And again, if we applied a proper pleading standard, this would be, hey, you have arguments. That's fine. This is for discovery and summary judgment. This isn't for motions to dismiss.
That's one thing that among the things that I found most shocking when I started doing these videos and comparing US to Canada. The first thing was the difference in freedom of speech between the US and Canada. The second thing was the propensity or the frequency with which motions to dismiss are granted in the United States. I said, whenever I see these things, Sandman was the first one I saw. I said, there's no way in hell this is going to get dismissed. This is a hearing on the merits, that pleading. And although I was vindicated, on what was it, on reconsideration, I've seen decisions get dismissed or lawsuits get dismissed in the States. Never in a million years, in my humble experience as a practicing attorney in Quebec, would they ever get dismissed here, because these are all invoking arguments on the merits as if to negate the allegations and not to take them for granted in the original suit. But I've seen the way the courts do it. Flynn, Sandman, what else was there? There was some New York Times one. It seems that judges in the United States make substantive determinations on procedural motions to dismiss at a rate which I found shocking, but I've become accustomed to. So, I mean, I guess the one question is, do they succeed? What was the next question I was going to ask? On the motion to dismiss, there's going to be a written response from Rumble? It's not, the judge just doesn't take that for granted?
Yeah, no, there definitely will. And there'll usually be an oral argument on it as well. Okay.
And now, so we'll see where it goes. I mean, it's an outright denial of Rumble's suit, but hopefully, they're going to crowdsource some knowledge here. And if their lawyers don't already know it, I said it's impossible that Google's argument it's convincing, or at least it's compelling, but it's impossible that it's going to call it true, for lack of a better word, because it's not like you're going to have lawyers for Rumble preparing this lawsuit saying, "Whoops, we forgot to allege the tying elements of a tying claim." To me, it seems implausible that it would have been an oversight. So I take for granted there's more, and that this is just a radical oversimplification and a distraction.
It's a function. I've complained to courts that when they grant or consider granting these motions to dismiss, they say what you're forcing plaintiffs' lawyers to do is to write 500-page complaints, because you're saying, well, you didn't allege this subconstituent component over here. It's like, okay, I can write a 500,000-page complaint that alleges every conceivable fact and inference from every fact to cover every conceivable grounds in anticipation of the case. But then you know what happens? They're like, oh, this is so long. Why is this so long? Because you made it so long, Judge. No, so in fact, I had a California Court of Appeals criticize a trial court for doing that. They're like, the trial court later was upset at it, but what they should have done is don't keep granting motions to dismiss on weak grounds that force the plaintiff to continue to file more, longer. I mean, I ended up with like a 393-page complaint in that case because the court demanded it by the nature of fleshing out every conceivable factual legal claim. So it's the courts are creating this nightmare, but they often act as a gatekeeper for protected privileged classes, which might be a good bridge to the Cheryl Atkinson case.
Okay, no, we'll get there actually. But the last question was, so why not make the motion to dismiss on the count one aspect of the claim? And is it when they proceed to discovery, they said in their lawsuit or in their motion to dismiss, they're going to proceed to targeted discovery. In Quebec, you can have an examination, at least under the older rules, and I suspect it's still the same, but you can do a deposition and then seek to dismiss after a deposition or after a discovery. But when they refer to targeted discovery, is that only Google targeted discovery of Rumble, or does Rumble also get to discover Google?
What they mean is that they'll let Rumble look at a few pertinent things, but not everything that Rumble wants to look at. So they'll probably follow this up with a motion for a protective order to limit the scope of discovery. That's their secondary objective. I mean, it's more egregious, or it's less egregious than what happened in the Cheryl Atkinson case, but it's a version of it where they try to basically preclude you from getting the facts to prove your case. I mean, my favorite form of motion to dismiss is, they deny you discovery and then they say you didn't prove your case. Ha ha. So it's courts love to do this sort of gibberish.
Okay, well now you're gonna have to present the Cheryl Atkinson because I'm a little bit I can't present it. So Robert, take it away and I'll see what questions I think I can ask as you do this.
Well, if you watch Hush Hush episodes or Deep State episodes at vivabarneslaw.locals.com, then this feels just like it, and that's because it is one. So Cheryl Atkinson, a great reporter, sort of Allison Morrow, you can also follow as sort of in the spirit of Cheryl Atkinson, smart, independent journalist who just is old school investigative techniques, who's not as politically biased as most in that profession and occupation these days. As a PBS local investigative reporter, local CBS affiliate reporter, did various weekend broadcasts, did a bunch, worked herself up to being one of the top investigative reporters in the country, 5-time Emmy Award winner, awards across the country for all kinds of things of her investigative reporting. In 2010, 11, that time period in 2012, she started breaking major scandal stories about the Obama administration and was on the lead for it because so much of the mainstream media, it was during the Obama era and the second part of the W. Bush era, that the media just became overtly and openly partisan increasingly. And so they tried to pretend there were no scandals during the Obama administration. Yeah, if you're blind and you're deaf, mute, maybe. But so she started, she was the one to help break key parts of the Fast and Furious story. For those who don't know that story, I mean, I dealt with a crazy prosecutor who was attached to that case in another case. And, they are people associated with that case, did bogus audits on me, tried to accuse my client of conspiring to kill him, tried to accuse me of conspiring to kill him, got a rogue FBI investigation, rogue U.S. Marshal investigation. Every insane thing that could happen in that case happened in that case. So that gives you an idea for the kind of people handling Fast and Furious. But the Fast and Furious was basically where the ATF and the Obama administration got the genius idea of helping to arm Mexican drug cartels, purportedly in the name of tracking the guns to have a gun control agenda. And one of the guns ended up killing a border patrol officer. So they tried to suppress it as much as possible. Atkinson was one of the big people breaking all of those stories. Then she followed that up by breaking the Benghazi stories. I think 13 Hours is the great film that perfectly really nails what happened in that case in detail, and the sort of moral horror of what the Obama administration, what Hillary did in that case. And again, Cheryl Atkinson's at the front of it. Well, around that time period, she starts seeing weird things in her house. First, the alarm system starts going on and off without any apparent provocation. Then all of a sudden, the TV, something's weird with the TV going in and out. Then all of a sudden, the phones are having problems. Then all of a sudden, the laptops and the computers appear to be going on and off by themselves during the night. And so she's like, what the heck? So she calls up, and supposedly a Verizon person comes out. Fine. But she has, she's connected. So she calls some smart security people, and they find some unusual lines being into the home, into the Verizon system. Calls the Verizon system. They come out. Someone came and appears to have fixed it, but it isn't fixed. And then that so-called Verizon employee disappears. She can never find him again. So and then about midway through, she does a bunch of FOIA requests. They stonewall. A bunch of Trump administration people will stonewall because of the idiots he appointed in a lot of positions. That's another rant for another day. So she ultimately pieces parts of it together, sues Eric Holder, sues other people, sues a bunch of John Does. And then for years, 4 years, the Department of Justice puts her in what a federal appeals court judge would later call the North Carolina Four Corners offense, which is a good ode given the Sweet 16 is happening today. That basically the four corners is where you run out the clock, and they put in the shot clock to stop teams from doing so. They basically file one motion after the next motion after the next motion, say it's over here and then it's over there, but it's not. So she's never able to identify who the other John Does are, and the Fourth Circuit Court of Appeals dismisses on multiple grounds, but one of them was a shocking grounds. First, they say if you violate the Fourth Amendment by spying on someone, that's not really, you can't do anything about it. No right to sue. Not under the Fourth Amendment. Now, Bivens doesn't extend that far. That's a new context. It's like new context. That's been in the Fourth Amendment since 1789. I mean, how is it a new context? But that was our Fourth Circuit, happy to run to protect the security state, which they do more than anybody in the country. That's why they take cases to the Eastern District of Virginia, like they want the Julian Assange case to go. And then they say, secondly, she also sued him because back in the late 1960s, we passed an electronic interception act. It has some other acronyms to it. But basically it said, nobody can spy on you illegally, and you can sue it was called the Wiretap Act back at the time. And so she sued them under that. And they're like, well, no, there's qualified immunity there because what high-ranking official would know that it's illegal to ask someone else to break into your home and spy on you? The Fourth Circuit said that with a straight face, one of the most ludicrous interpretations of the law. Then they followed up with a third principle, which is, hey, all those John Does you didn't name? It's your fault. It's not the government's fault for hiding that information from you for 4 years. It's your fault. So 2 years later, flash forward, somebody comes forward and rats out who did it. It turns out it was an old buddy and pal, somebody I humiliated multiple times, defeating his cases in court for multiple years, who then was put into a key position, unfortunately, under Trump, and that would be Mr. Rod Rosenstein. It turns out Rod Rosenstein, while he was the U.S. attorney in Baltimore, according to the information she was given, signed a special crew to do the illicit spying on her. And they did it outside the traditional chain of command. That's why they were using physical surveillance. Because these days you could just go through the NSA and the rest, they can spy on you without doing any of that. When you see physical signs of surveillance, it means it's an off-the-books operation. And I've had clients be a victim to it. In fact, including in that case I was talking about earlier. We found and tracked this was happening to him. So and not only that, they identify 4 other people as part of this team. And what's interesting is who those people were. 2 of them were part of the Silk Road operation. One of them's in prison right now for stealing Bitcoin during that Silk Road operation. There's a lot of reasons why Ross Ulbricht, I think I'm pronouncing his name right, he was defended by a buddy of mine, Joshua Draytell, the supposed Dread Pirate Roberts of Silk Road. There's a lot of evidence that they framed evidence in that case, entrapped him in that case, created false charges and false narratives in that case. And he may not be Dread Pirate Roberts, but that's for a future Hush Hush episode. As to who might be. But so those illicit actors were part of this that Rosenstein hired. I mean, it's right out of a James Ellroy book, except these people just not as skilled as the people that James Ellroy talks about. And 2 others, including one who is a top Mueller guy, who's now at CrowdStrike. And people can look up the connection to CrowdStrike and a lot of issues related to Hillary Clinton emails, to Russiagate, to a whole bunch of things. So a whole bunch of these actors that, the Frank Sturgises of the past that magically show up at, the assassination of this person, the assassination of this person, which you all can see at the Hush Hush episodes in part, magically show up against Cheryl Atkinson. She brings suit against them, and the district court says the same thing the Fourth Circuit said, nah, you can't sue most of these people. You can't sue Rod Rosenstein. He had no idea that it was illegal to procure an illicit spying on your house.
I didn't read the judgment, but he can't sue them because time barred, or can't sue them because of qualified immunity, or another reason.
Immunity. Said, one, you can't sue them under the Fourth Amendment because nobody can be sued under the Fourth Amendment for this, which is nuts. The second issue is whether about the actual law that specifically makes it a crime to do this. And it says, no, it makes it illegal for a person to actually do it. But if you procure it, If you ask somebody in the chain of command to do it, you're magically immune, under qualified immunity, because you could have no idea that could possibly be illegal. I mean, and the higher the rank you have, the more immunity you have, which is absurd. It's a very dangerous decision. She's going to fight it all the way up. Hopefully the Supreme Court maybe takes it one of these days. All this sovereign immunity stuff is gibberish. They invented qualified immunity. They invented mostly in the 1960s. Go back and look at the history. You used to be able to sue federal officers at the beginning of the time of the Constitution under common law theories like trespass, assault, whatever it is. And then they could raise a defense that, hey, what we did was lawfully ordered. And you could counter by saying no, because it wasn't constitutional. And then we dealt with that for hundreds of years. And then we decided to suddenly change all that, part in the 40s and part in the 60s. But when the national security state started to rise up is when the court suddenly said, we need to have some immunity. And that's where all this nonsense started. So it's a dangerous doctrine that keeps getting worse and worse and worse.
So, and the bottom line now is that was it a split decision? What is 3-0 of the Court of Appeal? They basically said you cannot sue because of qualified immunity for a Fourth Amendment alleged violation.
Or for illegal intercepts, which is a specific statute. Can't sue for either one.
Was it a...
And the higher ranking you are, the more immune you are. And as long as you make sure you procure it, that you ask somebody else to do it, you're in the clear.
Was it a unanimous decision from the Court of Appeal?
The Court of Appeal's earlier decision was 2-1. But the dissenting judge only dissented on the John Doe part. He didn't dissent on the rest. I mean, it's a disturbing area of law that most people don't know about, that she's highlighting by willingness to expend substantial resources, fighting it, contesting it, and exposing it. And again, one of the best she does, I think it's Full Measure News, I think it's called, a Sunday broadcast on the Sinclair Cable Network. Does a lot of other work for other places, has a good presentation on what happened in the news coverage of the election that people can find on the Hillsdale College YouTube channel. Great reporter, great investigative reporter. And what happened to her is just shocking. I mean, just shocking. And the idea that you can't do you can't even get into discovery. You can't prove your case. You can't find out the full scale of what happened because they hide and lie about FOIA. They hide and lie during discovery. They hide and lie through their judicial procedures. And then the courts affirm it. Courts say, good job.
I got to ask the obvious question. Political affiliation, appointments of those judges, do we know?
It doesn't matter in this space because the national security state is often the biggest advocates for various forms of sovereign immunity have been conservative judges. So they're Amy Coney Barrett types. So there's a lot of authoritarians on both sides of the aisle. And that's the problem. And Atkinson ended up having to leave CBS because they were becoming purely political. They'd always leaned political, but they were becoming overtly political. I think it was CBS that hired Ben Rhodes' brother. I mean, so it was just a crock. But she was sort of the canary in the coal mine, not only about how bad bias was becoming in news. People like her and Allison Morrow should be in investigative news. They shouldn't have to leave to try to do investigative news. And she was a canary in the coal mine about how bad the surveillance state was getting.
What did they ultimately do with any of the information that they were spying on her for? Did they...
she doesn't know. She just knows that they spied on her en masse, doesn't know what they did with it or how it translated to other things. What you can see is that 2 years later, she's out of CBS. So, did some of that information filter back? Did some of it become some sort of rumor campaign against her? Never know.
Yeah, I'm just reading this. We are witnessing a historic moment. The downfall of Western civilization, the rotten corruption has degraded all the pillars of our society. It is, look, the other thing is the bigger the government gets, the more prevalent this type of abuse gets. And it's a self-serving abuse because
it's favoring the state over the individual. And as the state concentrates and arrogates power to itself, the judges are the ones facilitating it and enabling it. And so there are still good judges who push back, like the Scottish judge who pushed back against the lockdown to protect the church, like a Canadian judge. Well, there was one bad ruling, one good ruling, but a Canadian judge who ruled in favor of free speech, like a U.S. judge, 2 U.S. decisions that came down that said that you have to protect the free speech rights In one case of academics, in the other case of lawyers, that you can't force people to say he, him, her, gender, whatever it is, the Jordan Peterson discussion. And another one that was trying to limit lawyers from talking about things, court also struck. So there's still some good, honorable jurists. There's some still based Judge Stickmans out there, but there's some other corrupt ones too, unfortunately.
Oh yeah, well, it's nuts, and I mean, it's So okay, so she's going to appeal to this. She's going to appeal presumably to Supreme Court.
Go back to the Fourth Circuit. Ultimately, this is whether the Supreme Court takes it or not. But people should pay attention to the case and clamor about the case in the court of public opinion so that it starts to get the attention of the right people. You look at all the yelling and screaming over the last 3-4 years about big tech, and what ultimately happens, you get Justice Thomas write a dissent saying we need to re-examine this. Mm-hmm. The way you get the courts to pay attention is you lobby first in the court of public opinion about how problematic certain rulings have been.
And, you know, it's a good segue. We'll talk briefly about the Quebec decision. I did a video on it earlier this week. Les Entrepreneurs en Action de Québec, Entrepreneurs in Action in Quebec, grouped a bunch. It's over 1,000 small business owners. I think it might be more. Grouped together, filed suit against the government. It was a lengthy suit supported by expert evidence. Dr. Bhattacharya, who I can't pretend I knew who he was before this, but apparently world-renowned doctor, presented evidence that some of the lockdown measures, in particular, forced masking kids from 6 to 12, harms the kids, doesn't have any real practical benefit, that the lockdowns are causing more harm than good, a bunch of stuff. They were seeking judicial review of the measures, a safeguard order. And, you know, like I explained in the video, when you go for a safeguard order or a provisional interlocutory injunction, you got to show irreparable harm, balance of inconvenience, color of right, all this criteria that you don't have to show on a permanent injunction. And there's a presumption of validity of the law that there isn't on a permanent injunction, where you just contest the validity of the law without there being a presumption of validity that you have to overcome on an interim basis. Their lawsuit was dismissed, 14 pages. Bottom line, summed up in one sentence, as relates to the forced face masks on children, the judge said, however minimal the risk is, they play a role in the propagation of the virus. However minimal that risk is, it's still too great. I'm loosely translating. But that's, you know, bottom line. They said it's no longer a question of balancing the risks or considering the pros and cons or the damages caused by the measures. The judge basically said they play a role, however minimal. There's a risk, and that risk is too great. And
any risk, one death is one death too many. It's that logic.
And you know, it's even one step further, because it's not even you know, concrete evidence. It's the risk of transmission. Then you know, then. And basically just dismiss the claim. The businesses, you know, are suffering. Children, we know what's going on in the world. But the judge basically just said, presumption of validity of the law, we presume that the law is in the public interest, and you have to overcome that burden on an interim interlocutory basis, and you didn't, because there's risk, and I don't want to be the judge who issues an order that unmasks, in the literal sense, children aged 6 to 12.
It's this deference to the administrative state, which fortunately we got pushback against in the Sixth Circuit, both to some degree in the speech case, but particularly in the bump stock in the gun case.
Yeah, another one. You got to set this one up. I mean, I know loosely. I've been following it, but give us the details.
So, you know, back after the Vegas shooting, the Trump administration kind of capitulated and went in and banned certain methods of changing a gun, and they got the ATF to declare that basically doing so made something a machine gun, and that was challenged right away because it didn't appear to meet the statutory definition of a machine gun, which goes back to 1934 and then was amended in 1968, then again in 1986, and occasionally after that, but mostly it stayed the same, because the definition of a machine gun didn't appear to cover what they were trying to include as a machine gun within it. So they sued under the Administrative Procedures Act and other provisions, but in particular, the big core legal issue is this tendency by the courts to say that the executive branch can write its own laws. It's called Chevron deference. It was never a good doctrine, never made sense. We should let the legislative branch write laws and the executive branch enforce laws, not have the executive branch writing laws. And this is a great Sixth Circuit decision because it goes through all of the philosophical, constitutional, and political problems with that doctrine. Now, they're applying it in the criminal law context because these laws governing machine guns have criminal enforcement penalties attached to them. And they're like, if you can and they go through all the history, going back to the 1600s, a complaint has been we should not allow the executive branch to write its own laws. That needs to be separated at the core, so one person, one part of the infrastructure can't do so. And they said in the context of any law with criminal penalties, no deference can be given to the administrative state. It also goes through how the administrative state really aren't better experts at anything in a wide range of contexts. So there should be no deference to them for that reason. And that their propensity to abuse their powers off the charts. They're unelected bureaucrats making these determinations about people's core rights and liberties. They also brought a challenge under the takings clause here. And they ultimately determined that, no, this was not a machine gun. There was no deference due to the executive branch. Common sense interpretation of the statute was clear that would not apply to this context. And so it was a great ruling as it applied to the executive branch writ large, while it had the incidental benefit of expansion of Second Amendment rights. It was not grounded in the Second Amendment. It was grounded in no more deference to the executive branch, because that's what we've seen in these lockdown abuse cases, too much judicial deference to the executive branch, because most of these laws are not passed by the legislature.
Yeah, well, I mean, that was one of the other issues, is alleged in the Quebec proceedings, alleged in Michigan, that these executive orders were issued under emergency health acts, never hit the legislature, just renewed month over month, and now we are living under the edicts of an administrative state that is listening to their own politically appointed medical experts, who are all listening to each other. And we had the mayor of Toronto, Ford, say, I'm just listening to the chief medical officer. I'm not an expert in this. So I'm just listening to my own politically appointed expert, who is confirming and expanding the ever expanding regulations that are, lo and behold, benefiting the government, and arguably, and I'm saying that just to weigh my words, arguably not actually producing any beneficial results, and possibly only the contrary. So the Court of Appeal is now sort of granting this decision on the administrative sense and not on the actual Second Amendment sense. Underlying issue is the Second Amendment. If it goes to SCOTUS, how do you foresee them dealing with this issue?
I don't think this Supreme Court will take up this case. I do think they will take up the Ninth Circuit case that said your Second Amendment rights end at your front door of your home. That case, I think, because it was en banc, because of this, they've been trying to dodge Second Amendment cases. They've got to start. There's tons of these cases coming up through the system. They're going to have to take one of them, and this one's probably the best one to take because it's the cleanest constitutional issue. The state of Hawaii basically has made it almost impossible for you to be able to carry a gun in open public. And what the Ninth Circuit en banc said, and en banc just means the whole court got together. They said that there's no Second Amendment right, no constitutionally protected right to be able to have a gun in public. And this is why I go back to understanding the second. I want to expand the idea the Second Amendment is rooted in self-defense, not guns. Because when the focus is on guns, courts will go to every possible gun regulation that's ever existed in history and find some pretext to say that's not constitutionally protected because in 1803, some small town didn't allow you to, like the movie Unforgiven, you couldn't carry a gun in town. The goal is self-defense. That's what Second Amendment protects, and its means of protecting that is the right to both keep arms and to bear them. And as the dissent pointed out, apparently there's no more right to bear them. There's only a right to keep them at home. And that doesn't, in self-defense context, that makes no sense because you often need to defend yourself in public.
Well, yeah, and it's tough to have a well-armed militia if you can't actually. I mean, if the militia doesn't exist in a house. I mean, although people are going to argue that the whole Second Amendment itself, the origins, is antiquated, depending on the side of the political spectrum on which you find yourself. Whereas, elsewhere in the world, people might now be looking at the Constitution of the United States with more envy than some Americans are. What I was going to say was, no. So that decision likely doesn't go to the Supreme Court.
The Sixth Circuit one on bumps likely doesn't go to the Supreme Court. The Ninth Circuit one, I think, has a very good chance to get there.
All right. And I got to correct myself. Premier Ford, not Mayor Ford. My mistake. I don't want to downplay his authority given what he's doing. Hold on. I just saw a super chat come in from Beavis Wallace. End of the hour topic, if safe for YouTube. I live on the border and all border town citizens are distressed by the caravans. However, we know who is governing Texas, which unelected bureaucrats are running the USA, and should we, the people, be concerned? And someone else asked, if I can find it, it was an interesting question on topic. Can Texas shut its borders down, citing a health emergency? Maybe part and parcel.
That'd be kind of funny if they did. That would drive people nuts on the left. It'll create cognitive dissonance. They'll be like, okay, we believe in autocratic power to shut down the government, but the government can do whatever they want, civil rights and civil liberties in the health, but we want lots of immigrants coming across the border. It's definitely an issue. Biden lied about it in his press conference. I think Peter Lavelle of the show, the Gaggle that people can follow on YouTube, called it the Depressor Conference because that's more of what it was like. And I think that was apt and accurate. And I'll talk about some of that more tomorrow on the political side of the equation with Richard Barris, People's Pundit. What are the odds at 2 p.m. Eastern Standard Time? On the legal side, there's no pressing legal issue other than the court has said that most of Biden's orders don't have to be enforced. The state of Texas sued and successfully sued, but there's still limits on what the state of Texas can effectively do in terms of border management. The problem is not as much security on the border as it is Biden inviting people to cross it. That's really the problem. That with the message Biden has put out, that's clearly they're interpreting as come one, come all, while you still can, particularly if you're kids. And that's what they themselves are telling reporters. And that's why the Biden administration shut down the press access to the border and they said, don't worry, after we're done covering it up, we'll let you go back in and look at it. Just incredible First Amendment violation, though they have unusual powers at the border. Those are the legal issues currently. The state of Texas only has limited abilities, even if they wanted to do it, because you can't stop the people from coming. This is why Mexico's upset at Biden. Central American countries are upset at Biden. They'd work something out with Trump to stop these mass caravans. Much of it smuggled in with cartels. It helps enable and empower cartels. Most of the girls and women that come up in this are abused or assaulted along the way. This is a human rights disaster, but Biden is basically incentivizing it and encouraging it, particularly by saying he's going to grant everybody that's got here already citizenship. So it's his path. That's what he's been saying. That's the big problem.
It is, and people can look this up. The last time I looked into it, the stats were something like upwards of 80% of the women who make the travel are assaulted or otherwise exploited. Using words properly here,
Yes.
and people don't appreciate that. I had another discussion with someone who is an intelligent person because we were discussing the reframing of the debate and some will call it use, and I'm going to call it absolute bastardization of the English language, where Jennifer Rubin, by the way, thinks the press conference was amazing. Biden excelled and the media embarrassed themselves. And she might only be right on the media embarrassing themselves for the exact opposite reasons she thinks. But they literally are referring to the cages now as enclosures and the crisis as a challenge, whereas the exact same issue, maybe even less so under Trump, was described the way it was. You had AOC crying, in front of a chain link fence, cages, a full-on outrage, a jubilant outrage by the media. And now the very same media changes the terminology, enclosures, challenges, and it's a result of Trump's policies. And maybe it was influenced by things Biden said last year or the year before, but ultimately we're going to blame it on Trump and not on what Biden actually said, which by all accounts has encouraged and exacerbated the problem. And we're going to change the terminology so that it doesn't elicit the same rage emotions that we were trying to get, under the previous administration. It's a wonky world. Like it's just it's backwards. But I think if I'm reading the field right, I think even people on the left who were once sympathetic to Biden and sympathetic to the administration are beginning to turn, and even some in the media. But maybe I'm just being too optimistic.
Well, he's brought immigration back to the fore, and it's not an issue that plays well for Democrats over time. So on the political side of the equation. But on the legal side of the equation, there's only so much that can be done. The only case that's challenged some aspects of the Biden immigration orders has ruled that what he was doing was illegal. But that only has limited impact.
Now, I wanted to bring up, we on the subject of ridiculous government orders, Robert, I'm going to try to screen share, so let me know if you see this. This will be a first. I'm going to screen share an article from The Sun. I swear to you, I thought it was a Babylon Bee headline when I read it. And when I read the article, it's even worse than the headline. I'm going to go ahead and share screen. Chrome tab, weddings return. Can you see this, Robert?
Oh, yeah.
Okay, weddings return. Where is the headline? Where is the bloody headline? Whatever, here. Weddings return on April 12, and brides and grooms can kiss even if they haven't been living together. I swear, 10 fingers to the sky, I thought this was a joke headline when I read it. And the further down you go, the more ridiculous it becomes. The weddings are limited to 15 people and can only occur in certain places, outdoor places, places of worship, and one other place. Oh, here we go. Celebrations are only allowed to happen in places of worship, public buildings, or outdoor spaces. All other venues, about 7 and 10, will have to remain closed until restrictions are eased. But there was one thing that was even more, how do I go down? Oh, nerds. Oh, I can't, wait a minute. Oh, I can't see the next part of the article. Well, this was a fail. It was, let me just close this down now. Hopefully I don't kick myself out. Oh, what was it? It was, oh my goodness, that's right. Setting aside certain exceptions. You got to go read the article, people. They set aside certain exceptions. There's social distancing. Nobody can come within 2 meters of each other, but they've made an exception for the bride and the groom on their first dance, and their first dance only. I swear to you, I'm going to take this off. I don't like this view. I thought it was a joke, and reading into it, it became even more of a joke that they made. The government, the benevolent government, has made an exception that the bride and the groom can dance together, but only the first dance. We're living in an upside down world. There's no way to describe it other than that.
Oh, no doubt about it. I mean, like I said, I'm just waiting for somebody to announce that in order to defeat COVID, you need to walk to work, hopping on one step and singing a song, and just watch how many people will do it. Because I mean, at this point, it's been an incredibly successful experiment on social control.
Here, I'll post a link to the article so everybody can read this here if I can do it. Yeah, there we go. Okay, boom, chat. Yeah, they make an exception for the bride and groom, but only for the first song. It reminds me. I mean, I was reading the article and I could only think of the scene from Braveheart when they allow the couple to get married, and then the guy, the guy on the horse says, "But we're gonna impose prima notte." And it's like, this is like the government getting personally involved in the most intimate aspects of citizen life, and like the headline, puts the can in caps, like people should be grateful for the benevolence of their supreme leaders. Like in Quebec, our curfew, which is still in effect, by the way, was supposed to end on February 9th. It only starts at 9:30 now. Thank goodness for logic and science. All right, Robert, what do we move on to now?
Well, there's one person that doesn't have to worry about any rules, and that would be the dear son of the dear leader, His Fraudulency II, Mr. Hunter Biden, who it turns out there's even more crimes he's been allowed to commit with immunity and impunity. And this time it implicated the Secret Service and implicated key Trump administration officials who helped cover it up and hid it from Trump himself. A recurring theme of Trump not always appointing the best people, but putting that aside, it should be shocking. It's sadly not. But the backstory of what happened is just one more example of a two-tiered system of justice.
For anybody who doesn't know it, I'll give it a 30,000-foot overview. It might even be just the overview. Apparently, in 2018, Hunter Biden went to procure a firearm and filled out a form on which he inaccurately responded to past consumption habits. That I think is the bottom line.
It was not a health stick. It was an unhealthy version of that.
Yeah, it was. I won't even make the joke. We all know
there was a crack in the foundation.
It was. We know what it was because he was dishonorably discharged for the very reason from the military. So, he false answer on an application to procure a firearm. Apparently,
which is governed by federal law and is a perjury and a false claim charge for multiple years in prison.
It's a felony
for you and me, but we're not named Hunter Biden.
So his girlfriend or wife, I don't know who she was at the time.
This is the other fun part of the story. So Hunter's way of consoling the widow of his brother was he decided to bang her, because apparently that's how they handle it in the Biden family. It's like, oh, honey, that's so sad that your husband's dead. Why don't we have an affair? And so that's who it was he was having the affair with.
Well, so in fairness, under certain religious laws, it is a brother's obligation, or it is a spouse's obligation, to marry the widow of their spouse. Now, the only issue is one questions, or one can ask.
That might be some centuries ago.
It was centuries ago. There was social reasons at the time, but the main question is, how and when did the relationship start? I can foresee it.
Very quickly.
I can imagine it happening. Everyone is distraught, and I don't mean to make light of that. But the question is, like, did it start earlier? But that's another issue. So it's the Bidens, so they're just a very touchy-feely kind of family. The chat has now gone a little crazy. I'm going to ignore the chat for a second. So Hunter Biden's brother's widow freaks out about it, takes the firearm and throws it in a dumpster, which, from what I understand, is also a felony.
Of course, because that's how guns get out on the market street and aren't in where they're supposed to be controlled. Put in a random trash can. And apparently she was concerned about his drug habits, potential assault risk. There was money issues. There was also some other issues. There were some photos on that laptop that might have been some other issues with some kids.
So without
leave it at that.
Without getting into that, which was, the story, the time the good social media censored an accurate story. She chucks it in a dumpster, which incidentally was right across the street from a high school. Then when he flips out and tells her to go back and get it, she goes back and it's not there anymore. As luck would have it, apparently a homeless person who rummages through the garbage found it. But apparently, and this is the unconfirmed element of the story, the FBI can neither confirm nor deny the existence of an investigation. The Secret Service cannot confirm the existence of this fact.
Yeah, but they didn't keep any notes of their illicit activities on behalf of the Biden. That's what they can confirm.
Apparently, the Secret Service paid a visit to the shop where Hunter procured the firearm and asked for the papers, and the shop got the impression that this was to erase the chain of command of sorts in the event that a crime were to have been or were to be committed with that now dumpster firearm. The guy said no. I forget who he gave the paperwork to ultimately, but no crime was committed with it because a homeless person found it and gave it back. And that's it. And this was in 2018. It seems that at least, I don't know what broke the story, because I Tim Pool did a piece on it. I saw you sent me a bunch of links. What broke this story?
The Gateway Pundit and some other people had been reporting on this back before the election, but the story was mostly buried until text got confirmed from the laptop where Hunter himself was describing what happened to Politico and others. And that's how it went mainstream.
And it went mainstream. Are there statute of limitations for these types of crimes? Like,
there are, but I don't think any of it passed. But it's another sign that, in Delaware, even the gun shop knew something was up. And that tells you what the reputation of the Bidens in that state is. You've had, family members get pulled over for DUI, get to take a walk, drug problems, take a walk. Hunter got pulled over in LA. He got pulled over in other places caught with drugs, with other problems. He had a gun pointed at him once over a drug deal, managed to never go to prison for any of it. A lot of this only became public when he knocked up the stripper. That's the song in Arkansas is a tribute to the old song from the 1890s. Ma, where's my grandpa? Going to the White House. Ha, ha, ha. And that's the nature of the situation. And it's a double standard. It's another scandal covered up during the campaign, covered up even by people that were supposed to be working for Trump in the White House, helping, and it implicates another law enforcement agency. In this case, the Secret Service. And Secret Service people, there have been rumors for years coming out of the Secret Service about Biden harassing people, swimming in the nude in front of women agents, groping Secret Service girlfriends and wives. There's been a lot of stories that come out, and now more and more are looking true. And it's just the scale of the cover-up is unconscionable. I mean, this makes us look like a banana republic in our standards and tiers of justice.
Well, this is going to be the good segue to the next subject, because talking about the two-tier system of justice, and anybody would be in jail for this. I mean, it's like, people make the joke, sorry, I had a boating accident and I can't find my weapons, my firearms anymore. Chucking it in a dumpster after having, feloniously lied on the application. It's beyond anything. And thus far, nothing has been done about it, and probably nothing will. And people are going to look at this and laugh, and they make a joke and call this computer Putin propaganda. But people in Russia are looking at this and saying, holy crap, at least we do our best to hide it in Russia. This puts us to shame. But then you go to the granny and pops, the grandma and her son. She's not really a grandma, Robert. She's 50 years old. And her son, who meandered into the Capitol Hill on the day of the riots, didn't break anything, didn't steal anything, were not stopped by security as they were meandering in. There's a 50-minute video where the son is saying, don't steal things, don't vandalize, we're not Antifa, you break something, I'm going to break you. The mother, at one point the son said, I want to take that gavel, but didn't take the gavel, referring to, I think, Nancy Pelosi's gavel. The mother is walking around looking at stuff like a scenic tour. The mother, 25 years as a nurse, no priors. The son, 2 misdemeanor marijuana possessions that were over 5 years old. And Robert, you're going to explain what happens to me. They get locked up on bail conditions. They got locked up for 3 weeks after having been released on terms which were themselves sort of over the top, but were stayed by the judge. There was an appeal of the stay of the bail terms, and then an imposition of bail terms, which were for the son. I mean, it was GPS tracking, house arrest. For the son, he had to submit to psychiatric evaluations if they so ordered. Same things for the mother, I think. And they were nonviolent. Violence occurred that day. There's no ifs, ands, or buts about it. These two were nonviolent. No priors for one, a worthy career and a respectable life. The other one, priors that could be irrelevant only if you want to overstate it. Given, what's the expression when, everything in the kitchen sink thrown at them by the court? Now it's up to you. I mean, first of all, explain actually how it went, because they were from Tennessee. They had a Tennessee judge impose bail conditions, which the Tennessee judge stayed. And I guess that pissed people off in D.C.
Yeah, I mean, it was extraordinary. I mean, so these are people picked up. One of them a middle-aged woman, one a man in his 30s. All they did is they were at the rally, walked down. By the time they got there, saw that the doors were open and police were not guarding him. So they didn't break anything. They didn't knowingly trespass even, because when they were walking up, and they're videotaping everything, and they would turn all that over. They walk in. The police are just standing there. They don't tell them not to go in. They wander around for 10 minutes and leave. Commit no violence, steal nothing, tell other people not to steal anything, tell other people not to vandalize, tell other people not to be violent, apologize to the police they're walking out, saying we still love you guys. Go home. They find out that they're being targeted. They initiate contact with the FBI at various levels, tell them where they're at, tell them they'll self-report, voluntarily produce the iPhone and their own evidence. Despite all of that, they get arrested, and the government demands they be detained without bail.
One thing, just so nobody accuses us of undermining or misrepresenting, it was either an interview or made public statements after they left saying that we're not going to put up with this crap anymore. We're going to fight, yada, yada, yada. I think it was the next.
I mean, and they clearly, there's evidence that they knew people had breached. There's evidence that they knew there was risk in going in. There's evidence that they supported at some level what took place in the sense of resisting the system and everything as they saw it. But they were mostly political, rhetorical talk.
Yeah.
Nothing that would be, in my view, that strong evidence of crime. No coordination, they agreed. No pre-planning. Nothing like no conspiracy of any. They're charged with a conspiracy, but that's a joke of a charge based on the admitted evidence of the judge themselves. Goes up to the chief judge in D.C., who's a political hack, who decides that she's going to abuse her power and screams about these being the most dangerous people and most dangerous crimes ever. Gets on her high horse. This shows you how politically corrupt the D.C. federal court system is. But people have witnessed that with the Flynn case, have witnessed that in the Trump cases, have witnessed that in their Hillary Clinton cases. 2 sets of standards over and over and over and over again. All the people who committed violence during the Trump administration inauguration, almost all of them got to walk free. served not a penny, they didn't do a day in jail. Unlike these people who didn't commit any violence, have no criminal record, deliberately chose to leave the only weapon they had, a knife and a book bag, outside before they walked into it with a cat into the Congress. The only thing he had on him was a taser that was holstered the entire time, and that's what they said was a dangerous weapon and obstruction of proceedings.
One more element. They picked up zip ties while they were in there.
This is, by the way, the zip tie people. So there's a bunch of people who've been, oh, look at how dangerous. They must have come in to kidnap people and da-da-da. There were zip ties they saw on the ground. They picked them up. According to the mother, she picked them up so someone else wouldn't pick them up and do anything. They didn't do anything with it, didn't try to do anything with it, didn't plan on doing anything with it, and left and dumped them. So in ways that they couldn't be picked up by others. So based on that, these are people that Eighth Amendment to the U.S. Constitution would guarantee them bail through historically always. What happened in the mid-1980s, we passed a Bail Reform Act, which for the first time said you could detain people even if they have no risk of flight. The only grounds for bail historically has been the person is at such a high risk of not appearing for purposes of punishment that you have to detain them pending trial in order to secure the enforceability of punishment.
It's so over the top. I mean, it's so over the top. They turned themselves in when they found out that the FBI was looking for them, when FBI posted on social media the images of people in the place. And the judge in D.C., Robert, correct me if I'm wrong, said that the reason to detain them was not the public security aspect. It was
the Bail Reform Act of 1984. They added a provision. And they said, now you could Minority Report style, cinematic reference, you could detain people based on their dangerousness. Now, that's imprisoning people without conviction of a crime. To me, that's just patently unconstitutional. The only limited grounds we've ever said is in the mental illness context. If they're an imminent risk to a specific individual, then you can detain them without a trial. I still have problems with that. My view is you just expedite the trial, but and that should be limited. Maybe you can do it for 2 weeks, 3 weeks until a trial takes place. But even under the Bail Reform Act, I don't think that was ever constitutional. The U.S. Supreme Court split 5-4, held it in a bogus decision that was manipulated, the Salerno case, manipulated to get there. There wasn't any reason for the defendant to really advocate for it. It was a mob case, so they had every bogus reasons to reinterpret it. And they said it was constitutional. In my view, it's not. They should revisit it. It's not what the Eighth Amendment provided for. But that ship has partially sailed. But even under the Bail Reform Act of 1984, though I encourage every lawyer out there, challenge it every time. I include every bail challenge. I say, by the way, if the grounds here are dangerousness, I'm challenging it as unconstitutional and a good faith basis to reverse the Salerno decision. But under that, you have to have clear and convincing evidence that the defendant presents an imminent risk to a specific individual that cannot be prevented, more likely than not, cannot be prevented by any conditions of your release. And here, I mean, and the judge did not even identify anyone that these people posed a risk for.
Yes,
as the Court of Appeals noted, is like you're talking about the past. You're saying what happened on January 6th. Who is it or maybe the inauguration on January 20th? Those dates have passed. Who is it they pose a risk to? Given that they didn't even act violently here, given they didn't even coordinate or conspire here, given they didn't even use weapons here, given they have zero criminal history, given they self-reported, given they provided the evidence that was used against them. How is it that these people are at imminent risk by clear and convincing evidence? By the way, they used a proffer. That was supposed to be for defendants, not for the government. They should have produced real evidence. That's another constitutional problem.
What's a proffer? I read that in the thing. What does a proffer mean?
You don't produce any evidence. You say, hey, if we had a hearing, this was designed in the Bail Reform Act so defense lawyers didn't have to waive Fifth Amendment rights against self-incrimination by being able to proffer instead what they could prove for purposes of bail. The government then co-opted it and said, we'll just introduce proffers. And that means they don't produce any actual evidence. And they lie about these proffers all the time. There's no remedy, because how do you prove that they lied about a proffer, what they thought they could prove? That's why the prosecution should have to produce, under the statute and the Constitution, actual evidence at the proceeding for what they do, but they let them get away with it because it's another area where they just want to lock up people in mass whenever the government asks them to. Courts are lazy. I've had magistrates that look at me sideways when I say this is an Eighth Amendment issue. They're like, what? Bail has something to do with that's a federal magistrates that behave that way. So it's an embarrassing problem in our constitutional jurisprudence. But great credit to the D.C. court, even to Obama judges.
Yep, I looked them up. It was Katsas was which one? Katsas
was the Trump judge who said this is so ridiculous. These people should be released right away. And the two Obama judges didn't want to smack around the heavily Democratic chief judge of the D.C. district. And so instead said, well, this is probably pretty bad, but we'll give you a chance to fix your mistake by releasing him on remand.
Where are they in the interim? They're out or
no, they've all been in prison this whole time. They were held for 3 weeks without even getting a hearing, which is a direct violation of the Bail Reform Act and the Constitution. And then the chief judge said, screw you, I'm keeping you in jail. And then that's when the Court of Appeals stepped in and said, no. We can't be this excessive. Let's not let the world know. By the way, this is where the Court of Public Opinion helps. They're getting so much blowback from more and more places in the Court of Public Opinion about exaggerating these cases, about lying about, including in the International Court of Public Opinion about these cases. That's why the Courts of Appeal, D.C. Court of Appeals, has its ear to the ground intensely politically. No court is more political in the country than the D.C. Circuit. They all think they're going to be on the Supreme Court someday. They're like every senator thinks they're going to be president. Every D.C. Circuit judge thinks they're going to be on the Supreme Court. But that has some utility because if you argue in the Court of Public Opinion, they're starting to see this looks bad. Even for us, that even though we're Obama people and on the Democratic side of the aisle and want these people run up on a poll, we don't want the world to think we're running them up on a poll. And that's where that idiot prosecutor yipping to 60 Minutes last week started to create huge problems. People are like, whoa, what is this guy talking about? He's going to bring back sedition laws? He's deliberately imprisoning people without trial to intimidate other people from politically protesting? You're not supposed to say that publicly, you nitwit. And that's why these judges had to step in.
So they're both still in jail now, or they're out on the other terms.
No, they're all still in jail. But they will be released soon on remand because this district court won't be dumb like Sullivan, and hopefully we'll get the message and release them.
It's just shocking. There's no other word for it. It's shocking that even if you consider the misdemeanor marijuana possession charges that are 5 years old of the kid, the mother has been a nurse for 25 years with no prior, nothing. And
zero.
I don't know if she's lost her job as a result of being in jail for endlessly. You can't exactly work.
Almost all working class people have gone through economic difficulties. Some people just did some dumb stuff that day, and people can go to vivabarneslaw.locals.com to look at the first hush hush episode as to maybe what the whole backstory is here.
Now, I wanted to thank Jamie for the chat. I hope you did not mean to say something in there and it sent it without it, but thank you very much, Jamie. This one might get to our second movie reference because actually it was something I wanted to bring up. Was anyone else impressed by the instantaneous parodying of insurrection just minutes after the riots, almost like it was coordinated? So I, at the insistence of a friend of mine, just finished the movie Vice with Christian Bale. It was good. It was, it's sort of, I like the Pulp Fiction type directing. I didn't think the story went into any sort of meaningful depth as to the levels of corruption of Dick Cheney. But the question I had, talking about that, where, when you have think tanks deciding what terminology to use that they know is going to run and achieve its purpose with the mainstream population, the media does it. And it was clear then. It was clear insurrection became the talking point. And if you all want to see the funniest one, you've all seen it, Power Through, Hillary Clinton back in 2016, the montages of the media running that concept, Power Through, and I saw in real time the effect it had on smart individuals who ended up, just because they heard it day in and day out, ended up repeating it themselves to explain the behavior. Did you see Vice? How accurate was it? And how Unitar and how crooked was Cheney in terms of Halliburton and the no-bid contract for the devastation in Iraq?
Well, I'll put it this way: he's a future subject of a deep state episode. So no question. One of the meanest, most vicious. Well, his daughter is definitely a chip off the old block. So just okay. Vile and vicious to the core.
Okay. Oh no, because it's fascinating. I said that movie glossed over, and I know Christian Bale thinks worse, but the movie glossed over what I thought I understood, and I understand it now only from what I remember at the time, which was nowhere near the level of analysis that I would have approached it with now. Okay, we've got a few minutes left. Do we want to do some questions from? Did we miss any subjects? I think we got everything.
I think I think we covered all the main topics. In terms of the three prominent questions or most common questions on the locals board, was one about vaccine. Oh, there were some questions about Hunter. There is some historical analogy to Hunter, by the way. He's Billy Carter tried to sell his own beer. Hugh Rodham was in all kinds of trouble, and the Clinton ended up pardoning him at the end. But basically, Hunter is, if you combine Billy Carter and Hugh Rodham, which is an appropriate reference, maybe, you have Hunter Biden's scandal problems. In terms of people ask about vaccine passports, New York is doing so voluntarily by creating an app for it. But clearly it's going to go further than that. And then Biden administration is announcing that they're going to try to require it. So we'll cover that once they actually issue the order. And so we would know what the legal landscape looks like. But it's going to be the next big legal front in the lockdown suits, and the related issues will be those vaccine passports. And there's plenty of us ready to fight and resist that, including Bobby Kennedy and some others. People ask about women's soccer equal pay. That's a joke of a claim. The federal court, even a liberal federal court judge, dismissed it. And the reason is because they're overpaid compared to men. In fact, what they're really arguing, this is an intersectional question, what Rapinoe and the rest are arguing is that they should get paid more than their African and South American other women's soccer teams, because they already are disproportionately paid more than those countries. They want even more of that money just for themselves, because that's the expense it would cut. It wouldn't come out of men's soccer pockets. It would come out of those other women's soccer teams' pockets where they're trying to develop it. So it's a bogus claim. There's no, as Trump, it was part of a famous meme where someone tried to ask him a question in 2016 as a woman, will you make sure I'm paid equally? And she even did this little this little SJW kind of thing. And Trump said, you'll get paid equal for equal work. And that was the old classic Trump move. And that's what the law is too. If there was a bunch of the whole gender, it would be a longer discussion than we can get into here. But I'll put it to you simply. If there was actually unequal pay for women and men, there would be 1,000 lawsuits tomorrow, because there's tons of people eager to file those claims. The reason why there's not is because when you dig into the data, you find that it doesn't support that. That generally is equal pay for equal work in America.
Go watch Nate Brody's breakdown. He published it today, an amazing analysis. He did one back in the day. But just a spoiler alert, is the women's team was offered the same contract that the men's team accepted, but they declined it because they wanted all the players on the team to get paid for every game, even if they didn't play. Whereas on the men's team, they only get paid if they do play. They got all sorts of health benefits, dental, vision.
They get a much higher percentage of the total. It's a real simple. Paul Joseph Watson has this fun series called on YouTube called Modernity. And his latest one did a very funny comparison of men's soccer and women's soccer, and why maybe people watch one more than the other. And so until men can compete in women's sports, which may be coming to us soon, that was one of the other popular questions on locals. Is Governor Noem's excuses legitimate? No, they're not. Two pieces of evidence for that. One, any complaint she now has, she had while they were discussing the legislation in the legislature. She didn't bring it up a single time. So she waited and she sandbagged them to the last possible minute. Second, other states like Arkansas and Tennessee have already passed laws and similar laws that don't have any risk of this problem. She's a corporatist at heart. She's always been Nikki Haley and Trumpian drag. And she got just exposed for it to the rest of the world because she cares more about her corporate lobbyist pals, as she always has. So the reason why she was able to do what she did on the lockdown, which was good, was because there were no big corporations in South Dakota demanding she do otherwise. Once they did step in and say for her to do something different, she hopped to their call rather than listening to the people of South Dakota. I don't think her legal excuses are credible or legitimate.
Go watch her say it. It's not convincing the way she says it, and it's illogical. Also, is you change the policy because of a threat of litigation, or you don't force it through because of a threat of litigation, as opposed to litigating the issue and then resolving it if and when the problem happens. It didn't make sense. It didn't make sense. But No, go watch Nate's video today for a good breakdown of the soccer lawsuit. The numbers are there, and you'll understand it, and you may become even more enraged as to how Joe Biden can come up and say what he said without having Daniel Dale fact check him and confirm pants on fire. Although maybe he's not even lying. Maybe he just doesn't understand it. He won't get back.
He did have a coloring book guide. He had a little coloring book guide. Okay, that person looks like this. Okay. And it was impressive. You have to respect someone who's spent 120 years in the U.S. Senate, as he explained.
All right. And there was one other thing before we leave. Rebel News has been fully demonetized on YouTube. So go check them out, support them by, Ezra Levant is asking for email addresses so he can have the email addresses of his 1.5 million followers. On Locals, we have email addresses. So if we ever have issues, we can contact you and send out, we don't send out mailers, but on Locals, you do have that information. So, you can't get shut down overnight and have no way of reaching your fan base. But go check him out, because apparently he's now streaming on Streamlabs, where there's no 30% YouTube commission, which I might have to go check out ourselves. But a good news outlet and good people who are fighting a good fight that deserve support as well. All right, Robert, what else? We did it. We did good.
Yeah, I think that covers it. I'll be at the after party with a live chat at vivabarneslaw.locals.com right after the show within a few minutes. And in the good news, another good news of the day was a little professor who helped found and helped really build a little university, a little community college up from the ground up, had been targeted by his wokester administrators because they didn't like how his lack of eagerness to identify his students by whatever pronoun the student chose. And so even though he went to great lengths to try to accommodate the student and everything else, wasn't enough. He wasn't woke enough. He was a devout Christian, and that was a problem. So they were going to run him off campus. He decided to fight the law, and he won. He went through the court system, won injunctions at the district court level, but they said, you can't sue the administrators for individual damages because, by golly, they didn't know what they were doing was violating free speech. So he took it to the Sixth Circuit Court of Appeals, and the Sixth Circuit said, no. Every administrator knows that's violating free speech. University professors have complete, robust right to free speech. You cannot coerce them and dictate them. You have the right to speak, includes the right not to speak. And if you don't want to identify someone by their chosen gender identity, that is your constitutionally protected right as a professor. And he established those rights as this little professor in a little community college for everybody going forward. So it was a great ruling and great reason to have good faith that the system can, as yet, still prevail.
All right, everybody. With that said, before you leave, hit the thumbs up and drop a comment just to explode the comment section. Thank you all for tuning in. Thanks for the support. Wednesday, we have Doomcock. Wednesday, 7 o'clock. It's going to be amazing.
The future ruler of Earth.
And we'll all see you next week. Enjoy what's left of the weekend. And Robert, stick around. We'll say our proper goodbyes.